We get the way they are if we are actually going to get it the way it should be. Thank you.
But my problem, my second leg of the question, he said he wanted to address it based on a review of the request. I don't know what it is.
No. On needs, let me give him back. Let him read it well, read the whole thing. Okay, sir.
With regards to a certain request, anybody can send a request, and the FIC ought to be able to determine whether this. Yes, what I'm saying is that any agency, for instance, can send a request, but the FIC ought to be able to know which particular, for instance, if an agency is asking for a particular request and the agency is not part of the stakeholders here and asking, the FIC should do a determination to be able to decide whether to give it or not.
Where we know there are very big criminals in the government. In a situation whereby a minister or somebody close to the presidency has an allegation, they will rely on this section to be saying that they are still trying to reviewing the request, and at the end of the day, they will say the request is not terrible. If we are going to do it internationally, we must move this one so that everybody will face the consequences. This is very important because this section, this particular words that is cited here is totally corruption. That word is said.
Seem to have with her is that acting as it is presently couched, it is conditional. I think so that we make progress. I think we just delete the latter part of I and just leave it. Response to requests for information by law enforcement and security agencies, full stop. Then we delete all other things that follow. Respond to requests for information by law enforcement and security agencies. Thank you.
Information that SSS should be having and give to agencies. Based on the need of the institution that is making the request.
Okay, please. Now, at the other one, to remove that part on based on the review of the request. What's your opinion on this?
Look, Mr. Chairman, I don't like Chairman has made some kind of proposition. And the LA, they know they're dealing with drugs. Police, they know they're dealing with their own aspect of the security. SSS and there is everybody knows his areas of jurisdiction. And you just ask me, because somebody made a proposal, I'm NDLA, and now I'll go for terrorism. I'm not to do with that. But if you do something with relation to my job, I'll do it. This is an institution of government. I will not threaten them. It's not going to you as an individual. It's going to an institution, another head of government. You mean you can give me information? Then what's the essence of this? Honestly speaking, it means this institution is not given what establishment.
Okay, so you don't agree with paragraph L?
Mr. Chairman,
you don't agree with paragraph L, the distinguish?
Yes, we must remove.
Okay. You don't agree, yes?
Mr. Chairman, somebody mentioned the issue of NDLA. If NDLA discover that Boko Haram is funding their activities through pushing cocaine, they have right to ask. Otherwise, they will not ask. So, for me, based on the review of the request, should be removed.
Okay.
Should be removed.
Yes.
Because we must make laws that do not give room for manipulation.
Go again. Yes, we
The review of request be removed.
Okay.
Supported.
Yes. Again.
Maintained.
Maintained. That is 1, 2, 3, 4, 5, 6, 7 to 5. Those who want it removed. have 7, and those who already maintained have 5. So we take it that we should remove that based on review. That's your question, isn't it? Yeah. We should remove that. Okay, so can you capture it for us so that we have it elegantly?
Agencies.
Bristol. Secure financial intelligence database for the storage of information and intelligence to enable the center to exchange such intelligence with law enforcement agencies and counterpart financial intelligence bodies in other countries. 4. And maintain a financial intelligence network with regulatory authorities, law enforcement and security agencies in Nigeria. Right? Advise the government. I'm overruling you already, Barata. Okay. Advise the government, supervisory authorities and reporting institutions on the prevention of money laundering, the financing of terrorism and proliferation of weapons of mass destruction and related activities. Okay. Develop and monitor policies and procedures to guide the sharing of financial intelligence in a confidential and secure manner.
Mr. Chairman, this one, it says develop and monitor policies and procedures which will guide the sharing of financial intelligence. And what the distinguished senator was arguing is that we should not place restriction, any restriction whatsoever, on the sharing of intelligence information.
Yes.
Set their policies.
So when guys now and revise to their own policies, we'll take
So
it.
let them do their policies. Let them regulate their policies.
So what should it be now?
So just add
Their policies. Their policies, yes.
develop and
monitor their policies. Develop and monitor policies.
That one is not, it cannot fit in place. I can.
Analyzing of financial intelligence. It's their own policy. We cannot start writing, develop their own policies for the sharing.
Their work does not simply stop at collecting and analyzing. It is for a purpose that they are collecting and analyzing. Sharing, then there's a problem.
By reporting institutions and advice supervisory authorities as to the performance by those institutions with regards to their obligations under this Act, the Money Laundering Act and the Terrorism Prevention Act.
Mr. Chairman.
Yes. You provide feedback, general or specific, on the value of information and reported by reporting institutions. Promote public awareness and understanding of matters relating to the functions of the center under this Act.
Why should I?
Direct the monitoring of accounts. They will also direct transfers. And they will also direct any other means of payment or transfer of funds. If it is not, let them It is not. If it is not, let them explain and let them put it appropriately.
General, Amos.
That's okay.
Karen? Karen?
Yes.
They have combating money laundering, financing of terrorism and proliferation of weapons of mass destruction and related authority activities. Carried. Review and...
Look at the center has power. That's lawmaking. So what we should do, they can either advise or something like that. If there's any defect, let them advise. But they can just sit down and just review it. That's the way they do it. Well, I simply advise, either they give advice. This is we share the money.
Of the law or review of the act, of the policies, on how to go about doing the day-to-day business. those such policies can be reviewed. I think this has something to do with the law of the law.
Majama.
Thank you, sir. I think what we should notice there is that it says in the consultation, 2, in the recommendation 1, it says every jurisdiction is expected to carry out a national risk assessment. And the unit that would lead that is the NFRC. The reason is you have to look at the risks available that you have in all the sectors, capital market, banking, insurance. And this is where you have all. So this is why it is in consultation. The good thing here, it is not the law that they are reviewing, but they are looking at the measures.
On the need.
Advice on the need to review.
Formerly the director, legal director in the Federal Ministry of Justice, and I'm joining forces to my colleagues here. I think this is a power, and because it's a power, we should not water it down by saying advice on the need.
Now, anti-terrorism. We have somebody is coordinating it, and you just simply the intelligence unit and tell them that go and review your approach. Military and Borno, Yola, what you tell them is down intelligence, go and do this kind of thing. They will never do it. They will never do it. So let's make a soft landing and know what we really need for this.
Mrs. Berman.
It is in consultation with the
How many chairmen do we have here now? I'm the chairman, please.
I'm sorry, sir.
I don't have the 2 chairs, sir.
I mean the chair of the FATEL, special committee of the FATEL. It is in... I'm sorry, sir, chairman.
Okay, go on. I'll just pull your legs.
It is in consultation with the regulatory authorities. For instance, if a regulatory authority wants to review its measures, it can invite even the NFIC because of the strategic position they occupy in all the reports that they take. And when you invite them on the table, they are in consultation reviewing those measures with you. So when I would say advice or not, like Madam had said, it will actually water down their powers. It's very simple to review anti-money laundering and counter-terrorism financing measures on a regular basis. In consultation, they can't do it alone. They have to do it with the regulatory authorities. And I think if they sit together on the table, like I said, they're reviewing something, whether in paper or in words.
On that powers, I think there's something inappropriate.
Some competent authorities and other financial intelligence units will or without a memorandum of understanding. 100 Provision Act. Yes, I did. Of the time mentioned in Section 2, you start with Section 2, then you get to Section 6.1 and Section 10. Carry? This Act and any other relevant laws, rules, and regulations. Carry? The Center also has powers to request for additional information from institutions and reporting authorities, including criminal investigation reports from any enforcement, intelligence, and security agency, a report involving the transfer of funds and securities to and from a foreign country, see records to track money transactions in banks and other financial institutions, D, tax returns of any individual or entity from the Federal Revenue Service, and E, declaration and reports and returns made pursuant to 1. The Foreign Exchange Monetary and Miscellaneous Provisions Act, the Money Laundering Provision Act, Custom Excise and Management Act, Banks and Other Financial Institutions Act, Securities and Exchange Commission Act, National Insurance Commission Act, Nigerian Deposit Insurance Act, Code of Conduct Bureau Tribunal Act, and other relevant laws and regulations for circulars.
General policy guidelines for the discharge of the functions of the center.
Yes. Go ahead, let him raise his observation.
Well, I look at a situation whereby the center is twisted. It's okay.
No, the essence of the board is
That is the purpose of the board.
every board can, that is B now. B, fix the remuneration, allowance and benefits of the employees of the center subject to the approval of the appropriate authority.
Yes,
Carry B, C. D will now become C. Regulate these procedures and make standing orders with respect to holding of these meetings, notices to be given, the keeping of minutes of these proceedings, and such other matters as the board may from time to time determine. Carry it? Carry it. Management and staff of the agency, the Director General. There shall be for the center a Director General to be appointed by the President of the recommendations of the Minister.
Which minister?
Minister is defined as which minister?
Is it?
Where? Which page?
Page 25.
Page
25.
Yes, interpretation.
So which minister?
We need to highlight the existing protocols, all to do media initiative against industry violence and corruption. At several fora, civil society and some other stakeholders deliberated extensively on this. And we are afraid of having another EFCC or another ICPC or another anti-corruption agency. We are interested in an agency that will function. We are of the opinion that the Attorney General already has so much that he is supervising. If we are talking about who should even, where this should be domiciled, if we are talking of ministries, finance is the most appropriate for it. Because we are talking of financial intelligence. But we are of a strong opinion, sir, that the presidency is our best bet. So we will have an agency that will have the mandate to function and is free from unnecessary and routine interference. I'm saying this from experience over time. I am a communication professional. I am a civil society expert. So we are of the opinion that the AG's office will not be the most appropriate place to situate this, considering experiences over time.
Okay. You see, your mic is not working.
It is the NSA's position that this agency, this Financial Intelligence Center, should be located in the office of the Minister of Finance. And we have canvassed this position very clearly. We do not believe that it should be located in the office of the Attorney General. The Attorney General is the prosecuting organ of the government of Nigeria. This agency's center should not be located in that office. And he is very, very particular about this. In other jurisdiction, it is the treasury. And supervises, yes, I know. He is particular that it should be the treasury.
The position of the NSS office is that this should be located in the Ministry of Finance. Let's have a refreshing contribution from this.
An independent consultant and an anti-corruption expert. From my experience, the Ministry of Finance is not free from political interferences. And the Ministry of Finance is also not free from outside influences. And therefore, if we are talking about the independence of an agency that will be very effective, I would not advise they locate it within the Ministry of Finance, either the presidency or some other location. Because in my view, even under the presidency, they will have better political support to be able to carry out their functions. And not only that, but I would suggest they also report directly to the National Assembly. Yeah.
Now, let me ask you, if you say Minister of Finance under political influence or interference. I suppose the influence or interference will come from above. And above in this case will be the presidency. So if you now take it there, then you are already saying, okay, we know this is where interference comes from, so you can as well interfere with this. I'm just trying to...
Yeah, that's why I gave a caveat of the National Assembly.
The National Assembly?
Yes.
Okay.
What I would like you to find out is that you can't do otherwise. So don't bring anybody around.
No. Sugarman,
of many observers are well rooted. You see, the purpose of this center we are creating is very, very enormous. It's very, very enormous. And if you allow political influence on it, you'll be used positively and negatively. It can be used also politically. It can shield some individuals. It can also be used as a political instrument against some individuals. Because the sense of the life of every Nigerian. So, we have to situate it somewhere. For me, it doesn't matter whether it is finance or justice. But there must be an intervention agency or intervention facet, as in the public accounts and INEC and so on, which make an annual report to the National Assembly. That way, people will not be shaded or it cannot be used effectively as a political instrument against individuals. So let us incorporate that annual report to the National Assembly, and that will solve the problem.
The center reporting to our general. But the caveat is, they should also send, is it annual report to the National Assembly? Is that kind of that amendment?
Where it will be so is there already.
We are agreed on 15.
Yes, we are agreed on 15 or just I think we are agreed on 15. So for consistency, please. I think whether
15 years. So instead of 20, should be 15 years. 15 years first, he resigns his office by a notice in writing addressed to the president through the minister. He dies, becomes of unsound mind or incapable of carrying out his duties due to physical or mental illness, has been declared bankrupt, or makes compromise with his creditors, has been convicted of a felony, fraud, or any offense involving dishonesty, or is guilty of gross misconduct relating to his duties. Carry?
I have a question here.
Yes.
Now the DG of that agency, because I think he's a public servant, and I think there's a law that forbids public servant from private practice. So I don't know in which can he become?
No, you can. Maybe you can't even manage your own finances, for example. You go around and you borrow even from your driver. Your driver's wife is selling Maggi. You go and take cigarettes from there. And there are several ways that one can be sent to a bankrupt. But I can.
So, I may not be able to pay you. And they are compromised with you. So this last is a bankrupt and will stop there. To compromise creditors, anybody can come and say, look, he's owing or I'm owing or something like that. Or that's katakata and that kind of thing. He's a bankrupt. There's a bankruptcy law on this. And we know what it means to be a bankrupt.
Okay, so the next compromise with his creditors, let's expose that one.
The removal of whoever is the director of this place will be more stringent than that provision. You see, I think if we tie it to the approval of the National Assembly, it should be better.
The approval is not trying to be
you see, Honorable gave us a synopsis that the center we are creating As enormous power. You see, the day you are appointed, yes, you have been appointed, but your removal should be more stringent. That's what I mean.
Appointment and removal that the National Assembly should be ordered with. The DG of this center is not at the same pedestal with the governor of the central bank, with the chairman of the EFCC, with the chairman of ICPC. And argument has been canvassed before now that in some other jurisdictions, a director, a person of the rank of a director heads this agency. I do not think that this DG should, his removal should be tied to approval by the National Assembly. It is not such an important position that the National Assembly should be ordered.
This office is very strong, very sensitive and powerful. It is this office, as we are all into the gospel, we think it is an office that will nip certain things in the bud. And it is likely that the occupant of this office, he must be insulated. He has to be insulated. One will protect that, yes, to be free and to be fearless in what he is doing. And sometimes the government itself falls foul of the law. The occupant of this office must be protected enough to take adequate steps to protect the citizens of this country, even for his own government. I think we must protect him better by subjecting his removal to an approval from the National Assembly.
If we're interested in checking money laundering and terrorism financing in the country, we must find a way of protecting the office and whoever that is occupying it. So our position is that while the president has the powers to appoint, that he needs to talk majority of the National Assembly to find. Thank you very much.
Every information, every transaction of any Nigerian in a center. So the person who is holding that information is very, very powerful. And let us be frank, there is as much corruption in government, in high places, as in the other sectors of Nigerian economy. So if that person is not, the keyword is protecting his appointment once he's there. He will come into contact with information that may be damaging to all levels of people in government. And if we create all these centers, we have been creating since morning, giving enormous powers for deciding every information, bank account, wealth, everything, in a particular center. And we do not now protect the person who runs it, and we subject the person to the whims and caprices of people in government. We are not serious. Look at what has happened in Russia. Look at what happened with the KGM's chief in America. Just remember what has happened. So it's very simple.
National Assembly, and then insulate the person by insisting that the removal of the person must be approved by the National Assembly.
Yes.
Okay.
That is the case I'm going to because simple rules of law and that if you have the power to hire, you also can fire. So instead we go back to review our position that the president appointed the coordination of the police.
So now, what about the recommendations of the minister? You see, I can speak to this.
But that first section of women.
General.
Yeah, we are meant it first. But just like the central bank case, the president
appointed by the president, subject to approval by the National Assembly.
National Assembly or Senate?
Senate.
No, Senate.
By the Senate. Okay. So when we go to removal,
yes, they will subject it also to
there is confirmation. So, Madam, can you couch this removal thing for us now? In the light of this new suggestion.
Subject to confirmation
By the Senate, yes.
Then we go to removal.
the reasons are valid. But we should also know that the SSS, for example, the NSA, the DGNI, do they come for confirmation?
All those offices which you mentioned, with due respect, are not on the same level with the sensitivity of this one.
A delegation of instruction under subsection 1 of this section shall be subject to limitations or conditions that the Director General may impose and does not relieve the Director General of the ultimate responsibility concerning the exercise of delegated power or the performance of the assigned function. The Director General may confirm, valid or revoke any decision taken by an employee in consequence of a delegation or instruction under section 1 of this section. No. It's 2:45. We close for lunch. We come back at 3:30. That's exactly 45 minutes from now. And this is scenario where.
Not necessarily from the agency, from other agencies. I'm aware of that. There may be a unit, there may be for ad hoc basis, there may be technical basis for having people from outside to come and assist now and then, but they should have the authority to also say go and come. That way I think would be the
So, experience when it was first set up, what really happened was people were seconded from the different agencies. But I also remember that that was really a concern by the FATSA. When will they have their own staff? The reason being that the staff must be unique to NFIC. Reason, the intelligence that you have is one that should be protected. Now, because we're setting up a new, it's not really new, it's just that we're giving it a legal framework. You will have to screen all of those people who are there today to know those that can actually become their own staff. But where they believe that there is some deficiency in capacity, they can get some people seconded for a period of time when they then have to get their own people.
The agency's experience will not be encouraged. All secondment from law enforcement, security agencies, ministries or agencies, deleted.
Yes.
Carried?
Yes.
So section 10 is carried?
Yes.
Carried. Section 11, security screening of employees of the center. That is subsection 1, A, B, and C, A, B, and B, and then section 2. Carried? When there is a comment, you delete it down.
I think they don't intend him to go back where he comes from.
We don't want a new agency, let them start with training so that they can make a career and grow. This one, I'm sorry, you have to understand what is working on the minds of the committee. The EFCC experience is very bad. I mean very, very bad. All the departments are headed by policemen who are just level superintendents, level 10 or 12. And then they become directors, and then they load it over people who got graduates who are being employed 10 to 15 years. You are on transfer, you are on level 10, 7 years you have not been promoted because there is no vacancy because a security man has been employed to help you.
There. So this lobbying within the barracks for people to go there. So we must kill that.
The staff, security screening of employees of the center. I mean, why should somebody be obligated to hold this kind of reckless checking in the normal thing?
It's not reckless.
A person should not be appointed or seconded to perform reform version of the center, unless maybe I'm reading the bill. Wait.
There must be screening.
Wait. But if you overload it in this way, nobody will ever be recruited online.
You go right to the villages. From your childhood, they begin to vet. So because of the sensitivity of this, the function these people will perform, I think it will be proper if that type of vetting is done. And the current ICPC, EFCC, they do that all together. They still do it. Yes. So in fact, some of the people that are being recruited, for instance, I know some, by EFCC, after undergoing training, they report to come, and they say, look, man, come. This is so we compile about you, come. So it can't be the same kind of screening that they do for ministers before they bring them for screening for so they need to.
At the fund of the center. 1. There shall be established for the center a fund. Yes, establishing departments and units. Carried? I thought it was already carried since. And it's consistent in the civil service reforms now. There must be what? Departments and sections, have you? Yes. That's what that department section is saying. Approved by the National Assembly for the purpose of center. Carried? C. Grants, gifts, and donations from international organizations and donor agencies provided that the terms and conditions attached to a grant, gift, or donation are not inconsistent with the functions of the center. Carried? Charges, fees, and other sums collected or received for services rendered by the center. Good, remove, because D not carried. Becomes D now. All other funds which may from time to time accrue to the center. Carried? Carried.
Which may from time to time accrue to the center.
Yes.
Can we know the kind of thing they're talking about? Let's have some thinking. Because all other funds, I can come and donate, maybe as a purpose.
Chairman, like investments now, no, the reduce on investments.
An individual can come and say, he knows, maybe I may be under investigation. I can come and just give money to the center, I can take this. Just give an investigation. So let's qualify it. It's just for us, it's open.
Okay, so.
From which source? Can we know from the consultant what funds are you?
I did.
Do they receive donations?
No, General Standard first.
It is usual to protect such agency from external funding. So opening it as they may receive funds arbitrarily that may not be in the interest of the center itself. Government, this is a body that's supposed to fund. So receiving funds from government and international donors is just enough. It's enough. Because we must protect the fund from arbitrary funding. Because why would anybody give the center any money anyway? So I think let us protect.
What of international?
It's there in C already. C has covered all that.
So E is the usual omnibus clause
that allows for
anyone anticipated law for center.
I think we're that's where we did.
So.
Can we know the source of others from this? The source of others from this?
Anticipated source.
E.
Well,
Sam,
I have understanding from
no, Madam.
Because you cannot say as we're sitting here today, it's not a fun, but it is good for us.
And that's the E something like that.
As we're sitting today, we cannot say, but there may be some funds that will be made available, so long as it's not.
That's from government.
It's government now, service-wise.
And donor agencies?
No, please.
Provided the term and condition attached to a grant, gift, or whatever donation are not inconsistent with the function of the center. Then you come under E. All other funds, which may sometimes approve, all other funds, which all other funds.
It will be investment.
How about?
Huh? For 2 years, Baga.
5-3.
5-3. Not carry. Subsection 1B of this section shall be a charge on the consolidated revenue fund of the federal government.
Carried.
Yes, carried.
1B.
Can I ask a question? The center operate.
They will get the take-off grant. It's provided for in the act already.
Satisfied with
He knows better than you. He just wants to know if we know what we're saying. Center shall not later than 30th of September in each year prepare and present to the minister. You remember we have said they will report to the National Assembly.
budget.
That's the budget. Carry?
Yes.
Notwithstanding the provision of subsection 1 of this section, the center has been registry due to unforeseen circumstances of this supplementary or adjusted statements of estimated income and expenditure to the minister for onward transmission to the National Assembly for approval. 15-2.
Okay, so read it now.
16.
So after reading that one.
16.3. The center shall keep proper regular accounts and other records of monies received and paid by the center and of the several purposes for which the monies have been received or paid, and of its assets, credits, and liabilities. Carry? The center shall do all things necessary to ensure that all payments out of this fund and bank accounts are correctly made and properly authorized, and that the adequate control is maintained over the assets in the custody and over the expenditures incurred by the center. Carry? This is noted by the center from the list and in accordance with guidelines approved by the Auditor General of the Federation, which accounts for audit. Carry? Yes.
Annual report. No.
We are talking about audited accounts.
No. Annual report. Annual report.
Annual report.
I think annual report is targeted towards
the end of the year.
Yeah, end of the year.
Including all the activities.
Yeah, exactly.
Yeah, the
so to review the annual report,
everything,
to see area of deficiency,
and
if they need budgetary provision. So, but normally by September at least, this annual report goes to.
But it includes audited accounts.
Yeah.
This one is talking about activities of the center, what they have been doing all along.
No, but it includes audited reports. To look at what is online to the bottom.
Chairman.
Yeah.
That is true.
Two times.
Two times. Yes. Audited. You see, today, the central bank, they probably think of changing the provision in the law which says they should produce their accounts by the 28th of February. It is actually too tight, and this can actually make your external auditors to overlook certain things. If you look,
so will you leave for 6 months?
I think 6 months. In fact, that's the general trend.
It's not too bad.
Because it should include the audited account. If it is just a report that excludes the audited account, 3 months will be fine. But if we want the audited account to be included, 3 months will be tight.
Of this section, supervisory authorities shall provide to the center details of every reporting institution supervised by them. Carry?
Not understood.
Section 18.
Not understood.
Know exactly what to give in order to maintain the database. It's a very important function for the center.
Okay.
Yes, sir. Because this, since they cannot do the actual work of registration of this is to ensure that that database contains sufficient information to enable the center to have a view of all the information required.
Okay. So, any comments?
So bad by me.
Yes.
So what are you dancing?
Sir?
Trying to say.
All the things that they are regulating, they must make the list available to the center. That's what
That's all. Subject to an inquiry in relation to money laundering, associated predicate offences, the financing of terrorism, or the proliferation of weapons of mass destruction being conducted on behalf of a foreign financial intelligence unit. Carry?
What does it mean?
A benefit from unlawful activity, or there are reasonable grounds for believing that material which may be provided in compliance with the directive is likely to be of substantial value, whether or not by itself to the financial intelligence inquiry for the purpose of which the directive is sought.
This is a requirement that for a person to be convicted, there must be proof that the person intended to have released the information. So there is knowledge. Knowledge is the element of the offense. Therefore, it can only be a defense if the person can establish that he did not know, for example, that the information is such that could cause problem if it is released. So he released it unintentionally. That is why it is a defense.
Fine of not less than 10 years, and you give him a fine of 10 million, and you give him not less than 2 years. I think it's run together. Compare it with the offense while officers in charge, who discloses information, and you give him only 1 million naira or a fine of not less than.
So what do you suggest?
So I think that the officer should carry more by
the person who made injurious disclosure is the offense is more.
So why don't you make the first one 5 million and this one?
This one 1 million. So this one,
We should carry the same way they can pay.
10 million, nobody can pay that money.
These are civil servants, so these are head officers.
Now you cannot carry this. One, for example, frustrates the conduct of the inquiry by hiding information. But the other one, we are looking at a staff of the center. And of course, we know.
No, we are not.
Okay.
A person.
We were told that for a person under 1A, most of the time there's a financial benefit accruing. The staff of the bank will normally not make a disclosure like this unless he is able to gain something. And for the type of investigation we are talking about, it may be in millions, in billions, and he would have gotten so much out of the disclosure. So he should be penalized adequately. For the staff of the center, we have said not less than 1 million. It may be higher. And imprisonment. And we know that after that, he can never work in the center again. So there's also the last punishment that he will not.
Why has not paid the 10 million? From where?
Sir?
1 million.
Like 1 million.
It's 1 million.
1 million for the staff of the center. For A, he would have made a benefit.
It's an institution.
Yes.
Officers of the banks can deny.
Disclosure, unauthorized disclosure, under the Constitution can carry 14 years. If you breach your classical acts, if you disclose without authority a classified matter, and what we are dealing with is classified. Yeah. So if I don't have any problem with 1 million, and the brain may not be able to perform an act, but the years of punishment should not be 1 year.
How many years?
I told you, I said, under the Constitution is 14 years.
14 years.
14 years, what does that
It's consistent.
And that is the 1962 Act.
It says an officer of the center who knowingly. So then why are we going to section 9 to say it's a defense, to say I didn't know? When section 8 says a person who knowingly discloses, then why are we going to section 9 saying it's an offense to say I didn't know?
For section 1 sub 3.
Number 8 says an officer of the center. Then number 9 says it's a defense for a person. Oh, okay.
Oh, yeah, it refers to the one up.
Okay.
Yeah, it's not for the officer.
Okay.
It's deliberate.
Okay.
I think I want to really support what Cliff said. I think there should be more onus of responsibility on officers of the center, even much more than that of the bank. Because from experience, some of these people who even give information as tip-off are these young officers who are account holders in an attempt to just keep and retain that customer so that they don't lose their job. But for an officer of the center, you know your responsibility to the nation, your responsibility to your commission, to that center that you work for, and you know the value of every function that comes to you. So I think the audience should even be stiffer on the side of the officer of the centers and even the...
We have agreed. I wanted suggestions on how we can manage
the punishment here. The provision says not less than 1 million. It can be 20 million, depending on the gravity of the offense. It can be 14 years, it can be 20 years. It is for the competitive, it is not less than 1 year or not less than. But we can increase the years and say not less than 2 years. And not
value of intelligence and source protection that you need to do. You have information. That center, we have said, we are giving enormous power. And it will be seeing things that other people will not see. You have access to information that other people will not have. And whoever is working there need to maintain confidentiality on the highest level. And if he knowingly, as we stated there, knowingly decides, for whatever reason, to breach it, he should stand in the same place as anybody breaching the official card.
So 14 years?
14 years. Okay. Is that when we start talking about not less than, we place discretion at the table of the courts.
That's true.
And when that happens, with recent experience, we know that anything can happen.
It can be abused.
Yes.
The judge
if you are making, if you say 5 years, you say 5 years. If you say 10 years, you say 10 years. If you say 14 years, you say 14 years.
Of this section shall complement any instructions carried out by supervisory authority. At the conclusion of the inspection, the center shall make a report of its findings and its recommendations to the appropriate supervisory authority. Any inspection of the type referred to subsection 1 of this section shall take place in normal working hours. I thought we had given powers to this to ensure compliance. I remember there was a section we did. It's been deleted. This inspection, I thought it's a regulatory power. Ms. Brown, what do you think? So do we really not delete it? And that is your opinion. Let me ask the parliamentarian.
The inspection is not wholesale, it's spot check. If they are doing an inquiry, if they are carrying an investigation, and they need a spot check to confirm what they have had.
But it is not predicated on if they are carrying out an inquiry. You make it look as if it's routine. When they wake up and they say, okay, we are coming for inspection, then everybody must comply. That's the import.
You need to empower the center. And one of the, they need that power of inspection.
Madam, you want to make them more powerful than the president of the country? All these powers will be given them since morning. It's not enough.
The inspection will be done to complement that of the supervisory authority. Are they going together to do the inspection? That is one, or they are going singly. I think it's proper for the supervisory authority to do this. If they find any cause for any inspection, You disseminate the information to the supervisory authority. They go and do the investigation or inspection. Your duty is to analyze and disseminate. I don't think they should be involved in inspections.
Thank you, Madam.
Authorities have dedicated MSF to examination divisions already. SEC has it, CBN has it, NICOM has it. Now you are asking the FIC to also go and do that. First of all, it will increase the burden of compliance on the reporting entities. Secondly, there will always be the issue of conflict. Right now, we have been experiencing that until the IMF team came to this Nigeria and on the project for Nigeria itself and suggested that, look, every agency should go ahead and establish, agency should go ahead and establish an MSFT examination division, and then the FIU, as it is right now, should hands off. Even that was even prior to understanding what we're doing jointly, and sometimes they go there, but the IMF is open. Look, FIU is not a core function of the FIU. For other FIUs and other divisions like the US consent now that does compliance, what it is compliance in terms of reporting and what they see, the report that comes to them. No, they don't go out and do some spot check. The regulatory authority has to do a joint examination, do the AMS-CFT examination, and then send the report to the FIU. So it's actually, there's a seamless relationship between the two agencies. There's no need for them to go out and do any spot check or conduct any examination. Thank you.
Can you see the wisdom in insisting on
players? Before we take a decision, that there's a comment there.
The document
is one of the key things that makes the difference between an effective center. That is why, because if they don't have this power, it's like not allowing them to move when they're supposed to move, if and when the need arises. So we went about 2 or 3 jurisdictions, and they said that we were successful and an efficient center to operate. They need this power. And we just didn't just think of it in the vacuum.
Madam.
That's why
Madam.
I mean, the collective...
we're in this business together.
Yes,
we cannot create a situation where obviously we know there's going to be conflict. One, we have created regulatory authorities and agencies, and they have their powers. This act of inspection is a regulatory power. Do this. Before you know it, even you will run from the office. Please.
That the center needed this measure of mobility to be able to go in and do spot checks, just spot checks, not actually a wholesale inspection on any institution. And we are convinced by the arguments used that they needed that power because, like the question I put to somebody and I say, how do they carry out effectively an investigation or an inquiry if they cannot verify statements that have been given to them, if they cannot go to the place of the document and verify that the documents they are receiving are correct. And I have been told that they can carry out an investigation and inquiry by the receipt of documents, and they can sit in the offices and do so.
In addition,
to this meeting, if you look at recommendation 1 of the FATA recommendations, the conduct of inspection and the general monitoring is now to be done on a risk-based approach. And risk-based approach is essentially driven by off-site regulation. In other words, you sit down in your office and you call for a report, you call for reports. This is the intent of the FATA recommendation 1. Now, even for the regulators that have MS safety units, we are no longer insisting on-site inspections. It is only when issues become very critical that you move out. You rely on those reports they send you. And if the establishment of the FIC is done in such a way that they have power to call for any information and receive it sitting down in their office, and of course they have the collaboration, the support of the regulatory and supervisory authorities, why do they need to engage in on-site inspection? I don't think it actually makes sense. And of course, we must realize that what we are having is the administrative type FIU. If you have an administrative type FIU and you give it power to move out to call for information or to ask for anything which you don't have the power to enforce,
it becomes a shame on them. And so let's really go where we want to go. I am a regulator, and I also was privy to the initial argument. The man who discussed with us comes from a different jurisdiction, and they can afford to do it now. But we have a peculiar arrangement here. We already have the regulators, and they are doing it, and it's working, even as it stands today. So I think we can relax it.
Recently, a big activities of a big multinational affected lives of several thousands of Nigerians. And as a member of the Senate Committee on Environment, we called them to come and account after visiting the various sites. And along the line, we were relying on what happened at the Gulf of Mexico. And to say that immediately that incident happened, Obama called the oil company concerned, the other, and they were heavily fined. So when we raised the issue of what happened in America here, the oil company came out and said, bring out the law that says polluters must pay heavily. We are trying to amend both NOSDRA, NESTRA, till today, we have not been able to amend to make sure that we make provision for stiffer penalties for an offender. We visited Ogoniland, Bodo, Ekedere, all of them, and Ebubu. We saw what happened there, apart from what happened from Bonga. We traced the issue from Bonga to Burutu and saw everything. So since that time, because this law that we are making is even for the future, we agreed that if there is need for an amendment, we can come back, but that is another man hours. That in a situation that we should provide for this now, so that at the end of the day, we don't come back to say, according to international best practices, but it was missing in our law. Because we have been told that very soon they want to go attend the meeting where they'll be able to stand up to say we have measured up to standard. That is the reason I asked the question. This comment here, where is the origin of this comment that according to international best practices? We don't just do this kind of thing without having a precedent in other client. Thank you.
We work with a consultant, and he came from...
That's the origin now.
He came from a jurisdiction that is a little more advanced than our own in terms of MSAP compliance. And they have had a lot of experiences working in this direction. But we had a challenge, even in buying his views, because we looked at what is on the ground in our own jurisdiction. And also, talking about international practice, we are looking also at the views of the IMF, because IMF have developed a lot of precedents and they have a lot of experience in the issues of MS safety. And they have visited Nigeria and at one point told us that the arrangement whereby FIU then, now FIC, was involved in on-site supervision was not good, it was not healthy. That they should concentrate in off-site monitoring, which is essentially their core functions. And we had tried to implement that even before we came to the level of drawing this bill. And it was working. So we had that understanding of what was happening outside with a view to looking at it in terms of what we have here. But here we are. Whatever you decide is what we're going to have. But the two sides of it is that if you give them power to conduct inspection, it may result into serious conflict with the regulators. But we also know that if they do not go out at all to ensure compliance howsoever, they may not be able to meet the expectations of what they're supposed to be doing under this law. So we have to balance it. We have to balance it. And for me, it's open for all of us in this meeting.
Samuel. Some few months back, we had an investigation. We asked FIU to do a placement on a particular account, to ask for documents, statement of account to be sent to us. And for 3 days, the compliance officers were just running around doing nothing. And meanwhile, that investigation was very sensitive and it could immediately be compromised. And we had them to invite the compliance officers ourselves, which ordinarily ought not to be, because if FIU is strong and able to then go to the bank and receive these things and look at this and take these things themselves, then we shouldn't have any problem. But that was a very critical stage that we found. So I think that the fact that we envisage conflict within our own local environment shouldn't be the basis for discarding best practice. If what is happening outside is that there is an opportunity for FIU to take further steps, I think that we should stay with that. But joint inspection, I agree.
Placing order or investigating. The particular case you're talking about is the process of an investigation. We are talking about inspection which is routine. Are you with me? This one that provides for inspection without warrant and all those.
No, I didn't. No. We can't go to a place without warrant.
That is entry and inspection without the warrant. Section 23.
No.
That's what we're discussing.
No, I haven't gone to that extent. I'm really talking about not whittling down the powers that the NFIC should have.
Okay. My chairman, can you balance it for us then? Can you balance it? The argument is less balanced. Okay. So we balance between, okay, they are not going at all, and they are going, but they should deal with the warrant. Is that what you're saying?
Frankly, the fact that there could be a possible conflict is not a reason why we should make the NFIC a good less tutor. The truth of the matter is this. In present-day environment, it is a risk-based approach that we adopt to inspection, meaning that they can actually sit within the confines of their office and carry out such inspection. What I would object to is a routine inspection. The language says, if need be. However, it can actually come to a rendition where the regulator and themselves can actually carry out a joint examination of that particular aspect which may have brought a challenge to the center. In other words, don't carry out routine inspection. If the need arises, reaching out to the regulator, do it jointly, or within the confines of the office, carry out your off-site inspection.
That means we have to revisit section 22
of reporting institutions jointly with the relevant regulator, so that in this case there will be no conflict. You cannot enter into the regulated entity without the consent and collaboration of the regulator. And that is the way we were doing it.
Draft it last year.
Yes, sir. The center shall
conduct joint inspection.
Inspections of reporting institutions jointly with the relevant regulator to ensure
that means it might actually defeat the purpose of the investigation. So that I think that was what informed putting without a warrant there.
Warrant it's an investigation and you think of warrant, that I'm a bit confused. Can we just clarify that?
Yes, sir.
All you do, the law backs you to enter and ask for. Because in our law, we have an omnibus clause that says you can enter into any regulated entity and ask for any information. That alone backs you up for inspection. So you don't need this warrant if it's the kind of inspection that we envisage for them. Okay, Mr. Sam can talk now.
Yes.
Provisions that enable us to enter into the premises of the regulated entity, carry out inspection or investigation as the case may be, and remove whatever document or property that we need for purposes of carrying out inspection. Now that we have agreed that there could be a joint arrangement, the law of the respective regulatory entity will now cover the FIC. So they don't need warrant.
if the FIC is going to have investigatory powers, then it would need a warrant to be able to do its work. However, if it is going to merely have an oversight function in terms of, getting coordination and the rest, like, well, as an auditors coming to look at your books and coming to inspect your books, then the warrant will not be necessary. My only problem is where you say removing documents or removing materials from that place. If you are then removing, then you will run into litigation if you don't have powers to so do. Even for law enforcement, even situations where you don't have, when you have immediate need to search or to enter into a premises and you don't have the time to go to a court, the rules, the law allows a senior officer to go to authorize the search, but that search must then be regulated later by going to a magistrate court to have it properly endorsed. So we need to decide on the issue of removal of documents, but that's where my problem is not about entry. If you are going with regulators, and that's like an auditor coming to ask you for your books, let me inspect, let me see what is there, and so on and so on. But then when you now talk about removing, and that's the area that I believe that we should look at. If you are going to remove documents, remove materials for whatever purpose, we need to be sure that we will not enter into any litigation from any area.
Is he envisaged that we will do that?
For instance, you want to confirm something, anything can happen. You are doing a law.
And it says, collect and keep in an accessible database. How is this collection being done? Is it part of what Mr. Cliff is saying? Collect and keep in an accessible database. They may produce evidence of his authority, blah, 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 just for it to flow. This is a joint inspection.
No, Madam Chairman, even from
recommendations. If any financial institution in Nigeria is into a transaction with any body or institution in those jurisdictions, the center can advise that financial institution to discontinue such transactions. Yes, sir.
Where the advice and the advice is not taken,
they will now recommend to the regulators to sanction them.
that's not in the law. You are adding that one.
So because if we are careful that we shouldn't say things that regulators will say no, we are about taking their functions.
Okay. That one will change to center. List of money laundering, terrorist financing, and proliferation of weapons of mass destruction. The center shall is necessary for the mitigation of risks of money laundering, terrorist financing, and proliferation of weapons of mass destruction, and B, advise relevant supervisory authorities on the application of risk-based approach by reporting entities in the conduct of customer due diligence depending on identified risks in money laundering, terrorist financing, and proliferation of weapons of mass destruction risks in relation to the customer, transaction or country or geographical area, product and services involved in the business transactions.
The court processes that you file before the court. All they need is the intention, okay, I'm going to sue you, I'm giving you 30 days notice, I'm going to sue you. But all these things, the cause of action, particulars of claim, that is what will be served on you when I sue you. So I don't think it should be in the notice to the center.
Fully associate myself with the position of the representative of the Prime Minister of Justice, Mr. Ike. So the truth is, even as it stands today, litigation is not the way everybody is going. We still talk about other methods of settlement of disputes.
you must not always go to court. I have an experienced personalist. I wrote an institution and I told them, look, we are taking you to court on an issue. And that institution has a provision that is on all fours with this. And we also gave all that we are required to give as particulars. Of course, they will know, why do you want to sue us? That's all we have here. And when we wrote them, the institution wrote us back and said, okay, we are ready to discuss with you. And so, for that basis, you can avoid unnecessary litigation. And imagine a situation where you are throwing it open for every Nigerian who has reason to want to sue FIC. You know the number of petitions that we, number of suits that will be commenced every day. I agree. It looks as if it's abridging the rights of the average Nigerian to sue. That's what it looks like. But let us look at other utilities around this provision. And again, sir, I want to put it on record that in many of our laws establishing the various agencies, we have this provision. In NARCOTICS, we have it. You have it the same? Yes. So, are we going to make a law here and repeal